Good.
Man versus technology. I will start over. Happy Tuesday, everyone. This is Tammy Trotter with Buy, Sell, Rent with TNT. I would like to welcome you to our June Home Ownership Month series. And we are on today with Esquire Lopez Thompson and Ms. Chandra Bettner Gray. We will discuss today some significant points within landlord tenant law, some things that will help you as we transition through this post-COVID, what we are in. And so what I'm going to do, I always like to start in a prayer. If we open up in prayer first, everyone bow their heads. Dear Heavenly Father, we'd like to come to you right now, thanking you, Lord, for allowing us to wake up to see another day. We thank you for your grace. We thank you for your mercy. We ask a covering over each and every household that is represented today. We pray that you continue to touch our communities, and we pray that we can continue to be a resource to those within our communities that we come in contact with. In Jesus' name we pray, amen. So I also have my partner, Tiffany Radamicki, is on the line as well. I have a short little bio of myself and Tiffany, just so you'll know who we are and what we do, who are you dealing with here today. So I'm Tammy Trotter, wife, married 22 years. I've been married, 22 years, and I have 3 children. I enjoy traveling, cooking, all that simple things. I'm a simple person. I'm a believer, and I'm also a housing advocate licensed in New Jersey and Pennsylvania. I'm the vice president of an organization called NARAB, the National Association of Real Estate Brokers. And as you all can see, I always use the term, I'm a Texas girl in a Jersey world. And so we have my partner, Tiffany Radamicki. And Tiffany is a wife. She's been a wife for 12 years. She's the mother of one awesome young man, young son. She is a believer, and she is also licensed in Delaware, New Jersey, and Pennsylvania. She is our treasurer for the National Association of Real Estate Brokers, the South Jersey chapter. So who we are not the attorneys. We are not the taxpayers or the advisors, the accountants, or licensed psychologists. So I always tell people, when it comes to the things that we do have great references, referrals for people that we can send you to, such as Mr. Lopez Thompson and Chandra Bettner Gray. So I will turn it over, and we can decide, Chandra, ladies first, or Lopez, would you like to go?
Ladies always first in my life, so of course.
Okay, so what we're gonna do, we're gonna have Chandra. Chandra is going to go, and Chandra, you can start your presentation. I'm going to go on mute, and I'm going to pull.
Okay, you're going to pull it up? Okay. All right. Hi, everybody. I'm Chandra Bettner Gray. We're giving Tammy an opportunity to pull up my presentation. It's fairly short today, and I'm kind of just wanting to talk about the impact of this pandemic, COVID-19, on the landlord-tenant relationship. So I did have an opportunity to present this to a smaller group of folks who are in the leadership of South Jersey NARAB, and very happy to share it with this audience here. So you may or may not know, because of this state of emergency, and I'm speaking specifically to the state of New Jersey, I'm sure that the considerations are very similar across states and into the tri-state area. But specifically for the state of New Jersey, there is currently a moratorium on evictions and foreclosures, and this is because of the stay-at-home order. Right? So perfect. Tammy's on the right slide. So Governor Murphy has signed these two executive orders, that's what the EO stands for here. One is March 19th, the executive order 106. This was suspending evictions and put this eviction moratorium in place. Also, like I mentioned, it does the same for foreclosures. Now, what it doesn't do, it doesn't stop filings from happening, or if there's a filing that has already existed, you know, a filing for foreclosure or filing for an eviction, it doesn't kick it out of court. But what it does do is put everything on hold. This is really beneficial for people who may be facing foreclosure. I know that, you know, some people are without income, but some people do have income, and this may be an opportunity to try to catch up, to buy you some time. For landlords who have tenants who, for some difficult reason, you know, have lost their job or whatever and can't pay, this can also buy the landlord some time to pass off grace. Okay. So although the court, you know, whatever is going on in the courts may still be going on, right here in the state of New Jersey, evictions have stopped altogether, right? So we're not having any hearings, anything right now, although I did just get something from the court, which shows me that we'll be going back to court soon. But as of right now, there are no hearings, none of that. And then there was this other executive order here. I'm just trying to move the, I can't really see it because of the pictures there. Maybe we could put them up to the top. Can you see? All right, that's okay. So the next one is specific to security deposits, right? So if a tenant gives a written request to the landlord that their security deposit be used for a month of rent that they are behind or will be behind, then the landlord must use it. I know for a lot of landlords, this can be alarming because this security deposit is put aside for when a tenant leaves, and if there are any damages, if there's any unpaid rent, if there's any unpaid late fees. In the state of New Jersey, landlord is able then to deduct these things from a security deposit. Now, if your security deposit has been depleted, then a lot of landlords are going to feel uncomfortable and feel like kind of like maybe something is being taken from them, some sort of security is being taken from them. But fortunately and or unfortunately, depending on what side of the matter you're on, Governor Murphy has said, look, if a tenant says, hey, use my security deposit, it's theirs to use, and they can, you know, it must be applied toward the rent. Now, landlords can request, after the emergency has passed, can request that the security deposit be Lord, I'm sorry, lost the word, can be filled again, whatever the word is I'm trying to say, it's gone. But they can ask for it back, and typically they would need to do that over time. So you wouldn't come back to your tenant and say, I need that full security deposit back. It should be broken down over months or what have you to replenish. That was the word I was looking for, to replenish the security deposit. Okay. So we can move on to the next slide. All right, so this is about interpersonal relationships. So considering that people are having a difficult time right now, it is a state of an emergency. And so even though, you know, states are making moves to reopen or what have you, you know, things have been hard. And for a lot of folks, people are not making the same kind of money. Some people are not making money at all. And, you know, we really need to lead in these relationships with honesty and integrity. So if you have the money as a tenant, you need to pay your rent. So I don't recommend that you just take advantage and you don't pay and you use your security deposit just because you can. Right. So if you don't need it, you don't use it. And the same way on the other side, using integrity, if you're a landlord and you know that, or you have reason to believe that your tenants may be struggling, you know, you want to err on the side of grace. Right. The governor has said unequivocally that he and anyone in power will frown upon landlords who are at this moment making threats or doing anything that will make a tenant who must stay home right now feel under pressure or feel like they have to leave, right? So that's already frowned upon. As people of integrity. We need to be led by that in our communications with one another. So if you're not sure where your tenant stands, then you should communicate with them, right? You should reach out to your tenants. Hey, it looks like your rent is behind, or are you struggling, or is everything okay? How can we work together? Because this communication may lead to finding out they have a good portion of the rent. Maybe they don't have the whole rent and they were too afraid to say something. And on the other hand, tenants, if you're struggling, say something. You know, I do understand how shame sometimes can come with it, especially if you are a tenant who's always on time, who's always paying your rent, and you don't want to reach out and say, hey, I'm having a hard time. But in both cases, you want to communicate. You want to err on the side of saying, reaching out too much in the beginning, right? So long as after the communication is had, that it doesn't turn into harassment, or it can't be interpreted as threats, right? So once that begins to happen, then we're crossing into criminal waters, and that's not what we want to do. All right, so I just want to encourage landlords and tenants to lead in that relationship, no matter how tense it is, with integrity. Okay, so we can move on. So we already kind of talked about this. I kind of hinted toward the fact that because of this CARES Act, and this is a federal act that's dripping down into the states, there is some room for homeowners, landlords who have federally backed mortgages, right? That they can apply for if they need some sort of forbearance. Now, depending on who your lender is, they can have all kinds of terms. So you want to make sure that you speak to your lender, that you understand what that means. Sometimes it means that it goes on the back of your loan. Sometimes it means they just hold it off for 3 months and then it's all due. So these are things that you need to investigate, but you also should be aware that it is available if you need it, right? So if you're a landlord and you're going check by check, and literally the rent that you received, you paid that mortgage, and you are afraid or you're fearful and you didn't know, now you know. You can reach out to your lender and say, hey, I'm having trouble. Can I apply for a forbearance? What are the terms of a forbearance? Okay. Based on the CARES Act, you have 180 days that is allowable, and then you're able to apply for an extension if it's needed, up to an additional 180 days, which I guess gets you close to almost a year if it's needed. But again, you don't want to take advantage of something like this if it's not needed, because it can harm you in the long run if you don't know all of the facts or what your repayment is going to look like. So those are things to consider. And, you know, you also should have that in the back of your mind as if we look back to the last slide, in your communications to your tenants or in your communication to your landlords, knowing that if you can get grace, that you should think about passing on grace. And that's really all I want to say. Now, well, the last thing I will say in the state of New Jersey, specific to the Anti-Eviction Act, if your tenant is just refusing to pay, refusing to communicate, and you're just frustrated and you can't do anything right now, the law does make provision for you to send notices within particular time frames. So I recommend, landlord, if you're in this situation and you're just in a completely unruly relationship where you can't communicate with tenant has outright refused to pay anything, and you know that you're going to have to move toward eviction, you want to talk to a landlord tenant attorney, if you can, who can advise you of what the notices are that are required, what those time frames are, so that when the opportunity comes and the court opens up, you will have done everything you can and you don't have to delay any longer. So I definitely recommend, if you're in that situation and you feel like there's no turning around in the relationship, that you want to get legal advisement wherever you are to help you navigate those waters, so that when it's time to go to court, you're ready and you've done everything according to the book. So that's all. That's my presentation. So if I can't really see questions. So, but if Tammy, if you see any questions, I'll take them. It looks like you're muted.
I'm sorry, Tiffany may have some questions. Tiffany, do you have any questions that you may want to pose to Chandra in that New Jersey format of landlord tenant?
Just first, I wanted to say thank you. Thank
Oh,
you.
it's
That
my
was all
pleasure.
wonderful, wonderful information. And I wanted to recap for our audience. I can't stress to you the importance of acting with integrity. If you can
Yeah,
pay, you should be paying,
absolutely.
because you don't want to put yourself in a situation where you're putting things on the back end because you don't know what that repayment looks like. That repayment could be due in full right at the end of that period. It's
Mhm.
not always just put on the back end. It's not a safe haven where it's just, oh, I don't have to pay any bills now. It's not that. So I just want to make sure that I reiterate to our audience that we act with integrity. This isn't a
Absolutely.
giveaway.
Yeah.
And this is the roof over your head.
Hmm.
So you want to protect that. So I just wanted to reiterate that, and thank you.
It's my pleasure. Absolutely. Thank you.
Now, a question that I have and always want to make clear, because I know you spoke about this in February when we met.
Hmm.
I have some tenants that are nearing the end of their lease, if not
Hmm.
at the end of their lease. Is it automatic that they go into a month to month? So
Oh,
let's
yeah.
say whatever term that they have, as long make sure they're verbalizing with their landlord to say, okay, I haven't been able to find housing. We will go, because a lot of people feel that they're going to be evicted for whatever reason if they
Right.
go in, their leases ended at the term via the contract,
Right.
but they haven't found housing. Is a month to month automatic?
Yes, ma'am. So in the state of New Jersey, it automatically goes to a month to month. And in the case of some contracts, so people really should know their lease very well. Some leases will say if you don't give notice of intention to vacate on either side within, let's say, 60 days of the expiration, it'll automatically renew for the whole term. So it's very important that you read your lease, especially where it comes to termination and renewal. But if that is not there and there's no clause specific to automatic, renewal of the full term or what have you, then yes, it will automatically be a month to month. In the state of New Jersey, which I can speak for, the courts, the courts really want to keep people housed. So you will not have to get out on the day that your lease is up. Okay, you will automatically be extended to the next month and the next month. Now it'll be, the onus is on the landlord if they want you to go to do some particular notices, and they have to have reason. So the lease being up is not enough of a reason to make you leave under the Anti-Eviction Act in the state of New Jersey. Okay, so landlords would be responsible to give communication significantly before the end of the lease about what their intentions are and what these tenants have to do. If their lease is about to be up and they haven't heard anything, then they will automatically be extended on a month-to-month basis.
And especially if they've been in good standing, that's one of the
Mhm.
things that they should not fear.
Right.
That, but the key thing is staying in communication so that everyone's clear and on the same page. Correct.
Right. Yes. But tenants should absolutely know that they do not have, now if they choose to get out on the last day of their lease, and that then they can, but they don't have to legally. And they
Okay.
should certainly be communicating though. They should be communicating. One party shouldn't assume one thing and the other assume another. They need to be in communication with each other about that.
Okay. Tiff, do you have any questions?
I
Other
do.
questions?
Yes, I do have a question. So, in the case of the end of the term of the lease,
Mhm.
is there a restriction on how much they can go up on the rent? Because I've heard that some of the new requirements, oh, I'm going up on the rent $200, and
Yeah.
the conditions they're making them unachievable,
Right.
so they
Yeah.
don't
So
renew.
I didn't mean to cut you off. Yes. So there is. And off the top of my head, I can't remember what the percentage is, but one, it must be reasonable. Two, I'm pretty sure that case law has established a percentage in the state of New Jersey that you can't go above. But I just don't know it off the top of my head. But yes, so there is a constraint around how much a landlord is able to jump up in the way of rent for the next month, right? And there are also constraints around late fees and all those sort of things. A lot of times people don't know, and tenants sign leases just assuming that they have to do what the lease says. And some of those things that are in leases are contrary to the law. So it's good for people, you know, when tenants can afford to have representation in these matters, even if just to review their leases, they certainly should do that so they can understand all those implications.
I have a question. I have a question as well. Do you have any input or knowledge or thoughts? Because I know you're licensed as a realtor as well, but do you have any input or thought about lease purchase agreements for those that may go into a lease purchase agreement? I know how I feel as a realtor when it comes to that, but if, let's say you get in the position and you sign an intent with the lease to purchase afterwards, and once you get into that lease, you realize it may not be what you want for whatever reason, and you decide you want to break that. Is there anything that we need to think about or people need to think about during that time?
Yeah, well, I mean, I think that you can get out on either side, right? Because I don't think it offers the kind of coverage or the kind of assurance that it pretends to offer, right? So even though we're saying we're going to hold this option open for you, it's not really a contract to purchase something. Do you know what I mean? In some way, it's a promise, but there's always a way out of that promise. There's always a way out. And so I wouldn't, if people want to enter those kind of contracts, I mean, I guess they can. They certainly should have representation, at least to explain to them what it means and what it doesn't mean. Because sometimes people sign these things and they assume this means I'm definitely buying this. I'm definitely going to be, you know, under contract, and you may have the right of first refusal, but there's no real guarantee. And we know, like, if you go directly under contract to purchase a home, there's no guarantee that you're going to close on that home, right? So to assume that at the point of signing a lease that you're assuring yourself something in the way of ownership on the back end of that it's not 100%. It's kind of a misnomer. So I, you know, if people want to do that, okay, but I certainly would advise having some sort of representation, at least with regard to reviewing that contract. But I wouldn't, I don't know that I would advise folks to do it, but if they feel like that's really what they want to do and they want to make sure they have some sort of right of first refusal, then certainly you can do that, but you can get out, I'm sure. And I'm looking at my my counsel here, and I'm wondering what his thoughts are, as it looks like his wheels are turning. So I'd be happy to hear what he's thinking about that as well.
Oh, okay.
Yeah.
Good evening. Good evening. Well, I'll speak to just that lease purchase matter. I normally don't advise clients to enter into a lease purchase, but there's a lot of time. And my name is Lopez Thompson.
Hi, sorry.
I wasn't introduced, but I usually use a vehicle called a contract for deed. And the reason why I try to use that is because there are times when a homeowner or the property owner is underwater. So they really can't convey title to the tenant or the buyer, the potential buyer. So the contract for deed pretty much sets out everybody's responsibilities, and it shifts the interest over to the buyer. Now the buyer can claim interest on the income tax return. They're responsible for the repairs, so on and so forth. So it's a vehicle. It's a way for the buyer to have more ownership interest as the possibly the debt of the seller goes down, and then the seller can then convey title to the buyer. Because in a lot of situations we're in now, excuse me, a lot of people purchased their properties in 2008, 2009, when the property values were real high. Well, those property values are no longer at that level. So a person could have purchased a property for $150,000 in 2008, but that property is only worth maybe $125,000 now. So they may want to get rid of it, but they're not able to get rid of it. So we use that vehicle, the contract for deed.
Okay.
That's awesome.
Okay. So that's what do you think, Chandra?
No, that was excellent. We don't use that, but I love the idea of it, because you essentially are saying what I was saying is that the way we do it, or doing it like a lease to purchase, it just doesn't assure a tenant of anything. So that was really awesome. Thank you for sharing.
No
So-
problem. No problem.
As I know, as our audience is coming in, we did have a question that came in briefly from someone. She said it's a great discussion. And her question was, is it a good time or bad time to purchase? And I know I'll take that one, we can all give our thoughts. I know for me, I'm seeing a lot of people come out. So depending on where your credit score is, that's a major factor, because those credit scoring models have gone up for different loans, depending on the loans that you're looking to obtain. So it's a lot of weighing in factors now that go into purchasing now. As of 3 months ago, I know we've been in the cave, 3 months now? 3 months. So that's one of the things. So would you all agree? Because I know we all do real estate in a sense in different avenues, but within the same circles.
So
Yes, I would.
Yeah, and I'll just chime in and say my go-to answer is always, now is a good time to buy. Now is always a good time to buy, no matter if it's today, tomorrow, yesterday, the coming days. It's always a good time to buy. Anytime you get a chance to become a home ownership and have an asset of value, it's a good time to purchase.
Hey, they
So that's
say
my go-to.
money's on sale with the interest rates.
Yeah.
So I'll just pause again, because I did not give my formality, and Chandra is very modest about her background, and she doesn't like for me to give her, but I'm going to introduce our next speaker, Lopez, and I'm going to give his background. Mr. Lopez Thompson has practiced law in Philadelphia for the last 26 years with a concentration in real estate, personal injury, criminal law. He is a graduate of Temple University and the Thurgood Marshall School of Law. Prior to attending Thurgood Marshall, Lopez opened one of the first Black title agencies in Pennsylvania. He has handled hundreds of mortgage, tax sale, foreclosures, quiet title actions. He is also, a licensed real estate broker in Pennsylvania. You have the floor, Mr. Thompson.
And good evening. First of all, I would like to congratulate my New Jersey colleague on such a wonderful presentation. I learned a lot myself in regards to the COVID-19 matters there. And I also would like to applaud you ladies for this forum, and thank you for inviting me to be here. In the last 26 years, I've practiced law primarily in real estate, but I've been in the real estate business for the last 36 years. I became an agent in 1933, and I became a NARAB member back in 1983. So I've been around for quite a while. During this time, I've had an opportunity to kind of see the real estate market from all avenues, because in 1985, as you stated, I opened up a title insurance agency here in Philadelphia, and it gave me the opportunity to look at real estate from somewhat, at that point, a legal perspective, the financial perspective, meet a lot of real estate brokers, and be involved in all kinds of real estate transactions. So presently, I am handling a lot of mortgage foreclosures, tax foreclosures, title problems, and occasionally I do some landlord tenant matters. And more specifically, in the last couple of years, and pretty much in Philadelphia and Pennsylvania's laws mirror New Jersey's laws. So everything is pretty consistent across the water. But what I wanted to touch on was some of the more specific tenants' rights in Philadelphia. I had the opportunity of handling a case last year that concerned lead paint in Philadelphia. There's an ordinance here, Ordinance 806, which basically gives tenants more rights and landlords more responsibilities when it comes to renting properties to families with children under the age of 6. And what's happening here in Philadelphia is you have to now, if you are a landlord, you have to advise the tenant that there's a law which mandates that that the tenant or the landlord secure a lead paint evaluation before that child moves in. And this can lead to some serious litigation that, as I found out. I had one particular case where the tenant moved in, she had a 5-year-old, and the landlord never gave the tenant the evaluation. And it has to be by a lead paint professional, someone who'll go out, they'll test the property to determine what the lead levels are. The Philadelphia ordinance basically states that that has to be done, whether there's lead in the property or not. Well, in this particular case, the landlord failed to do that. And the tenant hired an attorney who then came back and sued the landlord for all the rent from the first date of inception of the lease. And they were looking for somewhere in the neighborhood of about $33,000 against the landlord. So as we go into Philadelphia, the rights of the tenants become a little more exact, if you will. Pennsylvania and the federal government, they have their own say in regards to the do's and don'ts of landlord-tenant laws. So, and most of the time, and they're pretty consistent across the board. The first thing that you look at when you are looking at a property is how is the landlord marketing the property. So when the landlord has an obligation and they have a responsibility that they are fair to each and every prospective tenant. They can't discriminate against people in several categories. They can't discriminate based upon color, disability, family status, national origin, religion, race, or sex. So, you know, if a potential tenant comes to a landlord and the landlord has on the application, do you have children? That's a no-no. And that's based upon federal law. Their marketing and advertising also has to show that they're not discriminating against family. They can't say in their advertisement, no children in the apartment, unless I guess if it's a senior facility. Then there are rights regarding credit and the consumer check. They can pretty much, the landlord could pretty much say, I'm going to take an application from you, but they can't, based upon the application, then decide that the person requires a cosigner or that the person, based upon their credit, have an increase in rent or increase the security deposit. Their option is to say, well, listen, we're not going to give you this apartment. And then they have to tell the tenant why, if it was based upon a report that they pulled up. Now, once the person becomes a tenant, now they have to look at the rights on the lease, the security deposit. Now, a lot of landlords don't realize that once they take that security deposit, they have to return that security deposit in Pennsylvania within a year. After that year is up, if the person stays in 2 years, they have to give interest on that security deposit. Now, I had another case here in Philadelphia where and it was a nightmare case for the landlord. The landlord had evicted the tenant, but failed to give the tenant back that security deposit. And this case was taken all the way to a jury. The jury found in favor of the tenant for the $700 deposit. However, landlord, the attorney representing the landlord asked the court to reimburse her for attorney's fees. So the jury awarded $700 for the return of the security deposit, and the judge awarded the attorney for the tenant $9,000. Yes, so it's very important that landlords adhere to the security deposit law and make sure that within 30 days of that tenant moving out, that they return that security deposit. Another right is the lead-based paint notice. Everybody who moves into a property that was built prior to 1978 has to get a lead-based paint. And as I stated earlier, in Philadelphia, if you have someone under the age of 6, there has to be an inspection. Otherwise, there could be litigation. And it's my understanding that Philadelphia is going to move into where every property will have to have an inspection 90 days prior to, no matter the age of the individual. A landlord cannot discriminate in terms of how many people live in a property. They can't tell you that, you know, you can't have company in overnight. They can't tell you that you can't have your relatives come stay for a month. This is your property. You are there to enjoy the benefit of your property. You pay your rent, you can have as many people come in, although it's recommended that there are no more than 2 per bedroom if you had someone staying over. But who goes in to count how many folks are in the bedroom? Their rights if the clauses in the lease are illegal. A landlord could put a person out for an illegal matter, or for example, a person comes in and now they, instead of using it as a place to sleep, now they're using it to sell drugs. So that's a right that the landlord has. And on the other hand, the landlord can't forbid a person. They could tell a person, for example, no pets allowed, but if there's a service animal, which is a right that the tenant should enjoy, they can't violate that right and tell the person that, hey, listen, you can't have your service dog in there. The same way when you see people going on the planes and they have their service dogs with them, that's a no-no according to federal rights. So they have the right to quiet enjoyment. They have a right to a safe and habitable home. One of the biggest things here in Philadelphia is that landlord-tenant issues come about because of properties that are inhabitable. And inhabitable means you have no heat. Your doors are falling in. Your there's no hot water. There's no drinking water. All of those types of things, an inadequate bathroom. The person comes into the property and now the toilet won't flush. Those are reasons for people to call license and inspection and have the license inspection come in and take a look. And a lot of times it results in a violation to the landlord. Now, we go into a whole nother level, because when there's a violation to the landlord cannot collect rent. In Pennsylvania, or in Philadelphia more specifically, a landlord has to give 3 things to the tenant before the tenant moves in. They have to get a renter suitability certificate, which means they have to go online to the Department of License and Inspection and find out whether this particular property that they are renting is habitable. And the only way they could do that is to find out if it's suitable and it has no violations by license and inspection. So for example, landlord has a tenant from January to May. That tenant moves out in May because the toilet is not working. That tenant calls license and inspection, and license inspection comes in and gives a violation. So now tenant moves out. So July, landlord who never fixed that toilet rents out to tenant B. Before landlord can rent out to tenant B, he or she has to go online and find that certificate of rental suitability. Rental suitability.
Renters a suitability. Okay.
Right. It's a certificate of rental suitability. And what will happen is that broken toilet will pop up with the license and inspection. So now the rental suitability certificate, a license the landlord has to have, and a safe housekeeping booklet. Those are the three things that need to be present when there's a lease entered into by landlord and the tenant. So if the landlord then starts to collect rent without any of those three, when he goes to put the tenant out, more times than most, the judges will not allow him to put the tenant out in Philadelphia. So a person pretty much, they can stay in the house without paying rent until the landlord complies with those requirements. Other rights. If there's something wrong in the property, the tenant has the right to withhold rent. The tenant further has the right to repair and deduct from that monthly rent the amount that they put out in order to make those repairs. And the tenant also has a right to end the lease. So there are various rights, both on the federal level and on the state level. And now Philadelphia is really ramping it up in terms of a local level. They're giving tenants enormous rights. And I guess it has a lot to do with the fact that there are more tenants in Philadelphia than landlords who vote. So basically, those are the rights and obligations of landlords and tenants in Philadelphia and Pennsylvania. I'll take any questions.
I have a question for both of you, just in reference to like Section 8. How would a landlord move forward, and is there anything different? Because I know Section 8 has its own requirements of a landlord to have for the house and its inhabitability, but then also, what to be expected on both spectrums.
You want me to go?
You want to go?
Well, only thing I would say is regarding eviction, if there are, if tenants are Section 8 or have any sort of state subsidy, landlord has a responsibility to communicate with that entity first prior to filing anything. So if they have Section 8, for instance, then they need to be communicating to whoever their point of contact is at Section 8. When I say they, I'm talking about landlord, to say to them, hey, there's an issue with their portion of the rent, or making sure that that entity knows when landlord has intention to file eviction. They always have to notify that government entity prior to taking any action here in the state of New Jersey. And then they also have an added level of oversight. So when it comes to repairs and those sort of things, there are regular inspections that are a part of the Section 8 relationship that hold landlords to somewhat of a higher standard than maybe a tenant themselves would hold a landlord to. So there is a higher level of accountability when Section 8 or any government entity is involved in that landlord-tenant relationship. So that's all I have to say about that part.
Okay. I'll concur.
Well, Tiff, you have any questions? Other questions?
Yeah. So my question is for both of you, and it's regarding property management companies. So I have had a horrendous experience with property management companies on the Philadelphia side. I haven't really dealt with them a lot in New Jersey, but it seems as if they play by their own set of rules and it doesn't seem to line up with what's required. So I know that I've had a tenant move into a property and there was no testing done. So would that fall on the property owner or would that fall on the property management company?
Well, the case that I mentioned, it actually, it was the same type of situation where there was a property manager, and I don't believe they were licensed. If they were, they had someone like a straw broker acting as the broker of record for the management company, and they were brought in as a defendant in this lawsuit, but we couldn't find them in order to do a cross claim against them, because we believe that they were responsible, but they never had the inspection done, and we didn't make out bad on this case because we were able to settle it with the tenant for a small amount of money, and tenants use this law basically to offset their rent.
Mm-hmm.
So you will probably find that some of the management companies, they're not aware of this ordinance. But if anyone now who goes down to get a rental license, any landlord, they will see that it's a requirement. And when they attempt to go to municipal court, landlord tenant court, the court will tell you, you need to have these things. We need to know what they ask the landlord before they get into court. Was their child under the age of 6? And then you have to look towards the application, the initial application. How many people did they list on the application? Was it 2 people, the mother and the father, or was it 4, the mother, father, son, and the daughter? Mm-hmm. And at that point, I believe it's okay that you ask, well, how old are your children? We have to be concerned about whether your child is under the age of 6. So getting back to your original question, I would investigate the management companies as much as you investigate your tenants, because a lot of them will lead you down the road where you may end up in court.
Yes, and I do agree. It's a lot of they'll have what you called a straw broker, because
Yes.
that was the situation. So I found a property in MLS. It was represented by another co-oping agent. The co-oping agent gave me the initial paperwork and told me where to locate the initial paperwork, which was on a property management website. From then on, there was no more conversation with that broker or that co-oping agent. Everything was done through the management company. Now, the other thing I heard you touch on was asking for a cosigner and things of that nature. This definitely happened, and I don't know if it was a case because it was a university. The property was located in University City,
Right.
and I don't want to give too much away because I don't want to. I don't. If you
implicate anyone.
Yeah, and if you know it's in University City, 9 times out of 10, you're going to know who the property management company is.
Right.
But what they asked for is co-signers for each of the tenants because they were students. Now, they had a stipend and they could prove that they could pay for the rent. So I didn't understand why they needed their parents to also be co-signers. And they also made the parents pay additional. So instead of it being one application fee, it was an application fee for the actual tenant, and then there was an actual application fee for the parents. So there was 4 tenants, so they got 8 application fees.
Mm. And that's called an adverse action after they initially review the first report, but that's frowned upon. And that's something that shouldn't happen. They should just say, no, we're not interested. We can't give it to you, or say nothing at all. You weren't approved.
Right. So my last question is really more about disclosure. What are property owners, property management companies, what are they required to disclose? And the reason why I'm asking this, because recently I had a client that was interested in a rental, and I was asked, well, do you know if anything was anybody killed here? Did anybody commit suicide here? I was specifically asked that question.
Okay.
And what does the owner or the management company require? And I on both sides, Philadelphia and New Jersey.
I'm a little unclear about that. I would have to refer to the law.
Yeah,
But,
I was going to say the same thing about
Yeah.
the murder and all that sort of thing. I think, you know,
Right.
naturally, if you're asked directly that sort of a question, then you should disclose. But I don't know if you have the duty to disclose that sort of thing. I really, I would lean to the side of no, unless
Yeah.
you were directly asked. But I don't know exactly. But I do know that there is some probably case law around that.
Right.
And I do remember studying it, but I don't know if it was in law school or real estate school. But I don't know that there's a duty to say, hey, there was a murder here. But I do think if you're asked directly that question and you have the information, that you should certainly disclose that.
I had a situation where there it wasn't. I had a situation where I know an agent that had suicide, and then I had and the suicide had been it was a relative of the two, so within years of it happening. And then I had one where the grandmother died in the house, so the neighbors knew, I didn't know, and this property I didn't have like a disclosure. It was a REO property and didn't have a disclosure, so I had gotten the same answer as you. There wasn't a duty unless it was asked. The question was asked if something happened there. And for me, I didn't know, but the neighbors knew. So I just, was relying upon the neighbors because it wasn't from fact. It was hearsay per se.
Right.
It was hearsay. So, yep, that's one of those hard to, unless you Google the address or or wherever you're looking to reside.
I'm looking at something on Google and it says few states contain such a requirement. However, in fact, in some states, sellers are explicitly told that they do not need to disclose deaths on the properties to buyers. So in Pennsylvania, it says this is the case in Arizona, Georgia, and Pennsylvania, for example.
Okay.
Thank you for looking that up. I mean, that's what I would kind of lean to, like I mentioned, because people are disadvantaged as a result, right? So especially as a professional, like if you're the seller and you're asked, then certainly you should say it. But if you're the professional, you don't want to put your client in a position by giving an early disclosure about something that they'll never be able to sell, or they'll, always be in this situation. So, that's why my thoughts go in that direction. But, there you heard.
Well,
Well,
it says that the appellate court rules that deaths should have been disclosed by realtors in New Jersey.
I would do whatever the court says to do.
Absolutely.
Mm-hmm.
Absolutely.
Well, what I have a site that I had looked up found the other day. So for those that may be watching us either now or later on, and called Eviction Lab, that particular site will drill down accordingly to your state. So just like Lopez was mentioning, when it comes to Philadelphia, you have your state, and then you drill down to the city of Philadelphia, some of its particular things that they specifically look at that may not be looked at countywide or, throughout the state. So if you go to Eviction Lab, evictionlab.org, and especially now they have some rules that apply to the COVID-19 changes that are going on. So this is a website that I saw that was resourceful for people to be able to go and look at that are either not in our local, because you all have talked about New Jersey and Pennsylvania, but anyone elsewhere, if you have a relative or anything that you need to refer to. Were you saying something?
No, I just said that's awesome. I've never heard of that website, but that's really great.
I got it. Let me see if I can go back. Eviction Lab. I was on, I want to say HUD or one of the government sites last night, but like I said, it narrowed down some of the information, excuse me, needed for people to be able to know during the COVID time. It may have been, I got to it as well on the Consumer Financial Protection Bureau. That was another site that I wanted to make sure we mentioned to people, because there are some resources there for renters to be able to refer to as well. I know New Jersey personally has what they call the New Jersey Citizens Action organization, which is also there, and they advocate for renters as well. So I mentioned the Consumer Financial Protection Bureau. If for some reason that your credit is, and I know there's supposed to be a moratorium on our credit scores being affected for those that may have some situations with their mortgages right now. I think you can go there. You should be able to go there and report your servicer or your lender that's servicing your loan. So that's one thing to think about as well when you're moving through this time. Tiff, did you have any? I saw you move. Do you have anything?
No, I was definitely going to go into, you want to protect your credit. You want to definitely protect your credit, and we're experiencing something that we've never experienced before. So if your lender is reporting to the credit agencies at this time, they're not supposed to be doing it. There should be no reflection on your credit at this moment. I don't know how long that's supposed to last, but if it's happening, you definitely want to go to that site and report your servicer. That's really important.
I know as we're because we've had a lot of information here today, and I know I always tell people, you all have your each unique fingerprint, so we know that the people that we serve or will have their different situations that we may not have touched on totally here today. If we would, we'll have our lady go first. Ms. Chandra, if you would let them know your contact information and where you can be found, social media and everything. And after her, Lopez, you do the same as well.
Okay, awesome. So I am located in Mount Holly, New Jersey. Physically, we are seeing folks by appointment only right now, but primarily through Zoom. My address there, though, is 115 High Street in Mount Holly, right there by the courthouse. I can also be found on the website, www.bettnergraylaw.com, and on Facebook. So it's Facebook / I want to say Bettner Gray Law. So you can find me pretty much anywhere. You can also just Google Chandra Bettner Gray, and my contact information will come up. And thank you guys so much for this opportunity.
We thank you for joining us. Mr. Lopez.
Good evening again, everyone. My name is Lopez Thompson, and my office is located in the Winfield Heights section of Philadelphia, off of Belmont and City Avenues, in a condominium building called Park Plaza. My office is on the first floor there. I can be reached at 215-472-8-LAW, LAW, 215-472-8-LAW. I can also be reached by email at LopezT215@AOL.com. I got an old email address. AOL, they're one of the first dinosaurs. That's LopezT215@AOL.com. Our building is at 3900 Ford Road. 3900 Ford Road, and on Facebook, my firm is The Thompson Firm. The Thompson Firm on Facebook. And I want to thank you, ladies, for this forum. It was great, and everybody be safe out there in these trying times.
I have one, as we come to a close, just to close out, to say, use some words that we try to make sure communication is key, and trust. We have some resourceful professionals here. And a couple of pointers I wanted to point out. We've talked about some of the rental resources that were here. You can go to the Eviction Lab. You have New Jersey Citizens Action. And also you can go to the consumerfinance.gov where they have some housing assistance information, and also HUD.gov, there is information for renters there as well. As Tiffany and I prepare for June, June is home ownership month. And my first series covered landlord tenant law. And we know that as we go through life, be it if you're renting or if you're owning your home, that your home should be your sanctuary, as Lopez utilized, and that's part of the law. You should be able to live there comfortably and fairly with the rules abided by, and the laws abided by. And our next series will be series number 2. We will go over mortgage myths and the myths of working with a realtor as well. That'll be next Tuesday, the 9th at 7 p.m. And then we will also go over D3, which will be our third session, will be D3, get your house in order. It's a 12-step program to help you in getting in line with your savings, your investments, and also budgeting. So that's one of the things that we who have been members of NARAB, that's one of the initiatives that we have going on, and it is free. It is free. It is free. So if you go on the billiondollarchallenge.com, you'll be able to find that site, and the service is free. It does not ask you for your social security number. It does not connect to your accounts. You are able to go and start getting back on track. I know for a lot of us, so many things are going on and have affected us financially. D-Free will help a lot of us get back on track with your savings, get you a budget in order for initially, hopefully, getting you to some investments. And we are biased here. We like real estate because that's what we do, and we do it well. And then our 4th and 5th series will be the road to home, the process of purchasing a home. And we want you to know, we'll have probably some title on as well, because there are some pitfalls that people don't know that can affect you when it comes to your title. Not only your credit and all of that stuff, title issues can cause a lot of havoc. So in NARAB, these are our wealth building initiatives, My House in the Car, our D-Free program, and you can find Tiffany and I on social media as well. So we're on Instagram, Buy, Sell, Rent with TNT, Tammy T, my realtor, South Jersey NARAB on Instagram, and on Facebook, Buy, Sell, Rent with TNT, powered by Keller Williams Realty and Real Estate Dream Finders, so on and so on. As you can see those things. So we thank you so much for your time. I truly appreciate you, Chandra, as always, Lopez, and my partner, Tiffany. No, I love and appreciate her as well.
So Tammy, before we end, we in our current climate, we can't escape without making a statement. Our hearts and thoughts and prayers go out to the Floyd family, and Ahmaud Arbery, and all these lives that we seem to be losing senselessly and unjustly. So we definitely want to let people know that it's not just real estate. It's not just debt. It's not just landlord tenant. It's not just buying and selling. It's not just investing. We are all human beings. We all want to work together. We want to exist on this world together. And we all want to be treated fairly. So without further ado, I just want to
vote and census. The vote and census.
Yes, you have to get out and you have to go online. Like, it's so easy. Go online, do your census, call on the phone, do your census. The paperwork comes, fill it out, send it. Yes. There's power in numbers. Get to the voting booth. Everybody that's out there that wants to protest and do everything that you're doing, those same people need that same energy at the voting booth.
Absolutely.
I am going to end with that. And I want to thank you both. Very, very instrumental, very informational. And I can't wait to have you guys on again when we can talk about housing disclosures, because I really need you guys to talk to the clients about housing disclosures and why you have to do it. And if you don't, what can happen.
Come on now.
Sounds good.
Thank
Take
you.
care.
Thank you.
Thank you.
Appreciate
Have a
Bye-bye.
good evening.
You as well.
Bye-bye.
Bye now.
Bye-bye.